served on the branch manager of the defendant. And as my lord had directed, we try and ensure that the document requested for, which is the statement of accounts, were procured and eventually forwarded to Mr. Mbaka for his use, so that he can make some progress.
Yes.
That's basically the position this morning. So we have the documents now, and I want to also hear from him what exactly he wants to do with the documents, given that his witness, the principal witness in this matter, Mr. Megwa, had already given his evidence in chief.
Okay.
So whether he intends to reopen to possibly tender those documents through him to enable us commence our cross-examination, or what exactly he wants to make of the statement of account which he requested for.
Okay.
Thank you, my lord. I'd like to get the record and facts clear, correct, and straight. What was issued was a subpoena on the branch manager of the defendant, where the claimant's account is domiciled. My lord, a copy of the subpoena says that he should come. The subpoena was Duse ad testificando, so he will produce the document and answer questions that will be put to him. So the document, I did not intend to tender it through Mengwa. Mr. Mengwa doesn't have it before he filed this suit. He requested for his statement of account, which he has no custody over. It is your defendant, client, servant, branch manager that will bring it to the court. So if you finish your examination today, no problem. Mengwa can retire home. Your branch manager will come to court physically, or if he wants to come back, no, physically, of course. He will come physically and tender the document, the statement of account to the court, in obedience to the subpoena. The subpoena is not issued by Mbaka or Mr. Mengwa. It's by the honorable.
Please take it easy. You are shouting. Just be calm. Be calm. Make your calm submission, please.
So simply, if you are ready to cross-examine Mr. Mengwa, he is here. We do not have a statement of account with us here to tender, because the subpoena witness has not produced it to the court. The subpoena is known, it's clear. I didn't subpoena you or your office. It is the branch manager that has been subpoenaed. So after you have finished your examination today, we'll take a date during which if your client is not going to be available today, during which he will be available physically to tender or produce the document to the court. Afterward, we can pass our questions to him. Meanwhile, as advanced information, the claimant has read the document you say you forwarded and said that is not his statement. It doesn't reflect the status
so
of.
So, gentlemen, if I can interject, it's like Mr. Mengwa, the purpose of this proceedings today is to get Mr. Mengwa cross-examined.
Exactly, my lord. Exactly, my lord. I'm grateful, sir.
Okay, fair enough. Mr. Liadi, is that your take too? Do you understand what is happening?
Yes, I do understand, but I also think anyway for today, so as not to waste proceedings, because
yes, let's cross-examine Mr. Mengwa and then push it aside so that we can come back to the court and do whatever.
As the court is.
Yes, I think that would be better. Is everybody in tandem with me?
Very well, my lord.
Yes, my lord.
Okay, fair enough. So, Carlos Mbaka, your witness is ready to be cross-examined.
Yes, my lord.
All right. Push him forward. Folami, give him the remind him he was on oath.
Yes, my lord. Witness, can you hear me?
My lord, I wish to make a remark, my lord. I don't know, Mr.
Yes.
Sorry, Registrar. My lord, for purpose of the Evidence Act, it is required that someone that is a witness in the matter will not listen to the testimony of the of the parties during the hearing will be out of court.
Who is a witness?
Okay. Whether Mr.
Who is a witness other than Mr. Mwenga? Is it Mr. Tijani?
Mr. Dako is a subpoena witness. So whether he will log in and then he will come in when we have finished with Mwenga, or whether my lord.
Okay, Mr. Tijani.
Yes, my lord.
I order you to just fizzle out, please.
Okay, my lord.
So Mr. Tijani, you will be contacted when we have finished with Mwenga for your own testimony.
Okay.
Just hang around. Keep your device.
Okay.
Thank you,
but he's a subpoena witness, isn't it?
He's subpoena, yes, my lord.
Okay, then that means he's coming to court to come and do that.
No, he can testify virtually. It's in the United States of America.
Oh, he's in the US. All right, it's all right. It's all right.
But my lord, regarding Mr. Tijani,
yes,
as we speak, we don't have his witness statement too, because this is of saying he is someone there and he will be giving verbal evidence. I doubt whether that is recognized. Since he knows him and he knows what exactly he wants to get out of him, it's better we have a witness statement on note so that we prepare for that eventuality. Since Mr. Tijani is not our staff, we don't have issues. We can to pin anyone he likes, but we shouldn't also be taken by surprise. We need to know what he's coming to say before the court.
Who is that?
Mr. Tijani, my lord, because he's not even in the list of witnesses we have. Just remark, my lord.
My lord.
Yes, Carlos.
Yeah, there is no there is no rule that says Mr. Tijani must file a statement on oath in this suit. Mr. Tijani is an officer of the defender, a former officer of the defender. We don't know him. He was an officer that he was a HRO. So we have no relationship with him to bring him in. He is not our witness, not our friend. He's your own former staff, he's your officer. So he was responsible for everything related to staff benefits and so on. So how will we bring him as our witness? We have to subpoena him. Come and tell us what you know about the gratuity of this officer. That's all. So you say, of course, since how many months you are aware of his name? He was also in trial last time, so it's not new to you. If you have questions for him, for examination, you put it to him. When we have asked him a few questions, we are not taking much question for him. What he knew about the gratuity is what we are asking question on. It's not about whether he knows Mwenga or doesn't know Mwenga. He's your own officer, your staff. You have his record. You can't deny your former staff.
My lord, it's too early to indulge in all these big back and forth. If you say someone is a former staff of the defendant and you are still saying it's our staff, I don't understand that. Does it mean after he has left the employment of the bank still has control over his life or over him? I don't understand. And that's why we are saying we need to know what he's coming here to say. It's not just a matter of putting him before the court, then he starts saying things that are neither the pleadings of the parties or whatever. But my lord, when we get to that, I think we should make good use of today's proceedings. Let the business of today commence, my lord. When we get there, we will cross it. But I'm just standing at a note of warning so that when we raise it, it's strange.
Okay. So go ahead.
Thank you very much, my lord.
Yes.
Mr. Megwa, good morning, sir.
Good morning.
Yeah, good to see you.
Sorry, Counsel.
Sorry.
Please, may I remind the witness that is on vote? Witness.
Am I a witness?
Can you hear me?
Am I a witness? Am I the...
You are the claimant, but you are also a witness because you are
Yeah, a witness. Okay. Yes.
Okay.
Do you still remember you are on vote? You are still on vote.
You are aware?
Yes, I know.
Remember, you are still on vote.
I say yes, I know. I remember.
Okay. All right. Okay. You can.
So he's all yours.
All right. You can go ahead, defendant counsel.
Thank you very much. Mr. Megwa, a very good morning.
Good morning, counsel.
Yes. you recall that you deposed a witness statement on notes in support of this case on the 26th of January 2017.
Yes, counsel.
Okay. So, are you very conversant with the content of those witness statements?
I should. Yes, I am.
Do you have a copy with you there?
You know, I'm not your learned colleague, so I don't know what you refer to as.
Yeah.
He's referring to the witness.
The witness statement on note that you tendered along with some other document the last day you were in court.
Okay. Go ahead. Yes, I have it.
The one that started with the witness statement on notes of the claimant.
Okay. It's okay. Go ahead. Yes.
Okay. Now, in that witness statement on notes, you informed the court that you were actually employed by defunct Intercontinental Bank PLC. Is that correct?
Yes, it's correct.
Okay. And that particular employment, you commenced work with the Intercontinental Bank PLC in Lagos here. That
Yes.
was in year 2000 or thereabouts.
7 February, year 2000.
Okay. Then subsequently, you were seconded to their office in Ghana.
Yes, counsel.
Are you a Ghanaian?
I'm an Anambra man, an Igbo man.
Really?
Nigerian.
Okay. Now, by virtue of that secondment, you are still a bona fide staff of Intercontinental Bank.
In Nigeria, yes. And that's where I was earning my salary.
Okay. So in other words, the Intercontinental Bank staff handbook that was binding on all the staffs in Lagos or any other state in Nigeria is the same that is also binding on you even when you are working on secondment in Ghana. Is that correct?
Yes. Though there's one or two amendments, like some what Ghana can take care of, like giving me accommodation here. I mean, so.
That one is for convenience, and I think the main staff handbook also made provision for all of that. Is that correct?
I'm not sure it made provision for that, because we are the first outside the country subsidiary. So by then we hadn't developed the group system. So it didn't make sufficient provision for that. But go ahead.
Okay. So do you have a separate staff handbook for Intercontinental Bank PLC staff that are working in Ghana?
No, we didn't have a separate staff handbook, but like I said, there are some one or two like allowances you are paid.
Okay, but they are not contained in the staff handbook.
No, they are not.
Okay. Will I be right to say that your employment with defunct Intercontinental Bank PLC was governed by the staff handbook of Intercontinental Bank, and your letter of employment or any letter issued to you in the course of your employment? For example, if there is a promotion and some other perquisites, Is that correct?
Yes, I'm subject to Nigeria office.
No, I don't understand. Try and understand what I'm saying.
What was the question?
Just like you said so many things, I don't understand. So I have to breach what I'm subject to. I was subject to Nigerian office, the Intercontinental Bank PLC.
Just like so many things I said that you don't understand, or what you say. I want to understand what you're trying to say.
Yes, you went to, governed by this, that promotion. So I didn't understand most of them, but I'm just summarizing and said, but when I was in Ghana and throughout the time I was employed by Intercontinental Bank PLC, I was under the control of Intercontinental Bank PLC Nigeria, and the staff handbook there applicable to me.
Okay. Please, for purposes of these proceedings, the whole essence of this proceeding is to enable the court to appreciate what exactly transpired. If in the course of my questions, there are certain things you don't understand, please feel free to ask me. Don't assume. Okay. Or don't ignore.
All right.
I'm not interested in denying you whatever you justly deserve. So don't see me as your enemy. Ensure that you understand what I'm asking and you give adequate or correct answers to them, please. The point I'm that as far as your relationship with the bank is concerned, you are employed by Intercontinental Bank PLC. Are we on the same page on that?
Yes, we are.
And I said, by virtue of that employment, it is your staff handbook, the Intercontinental staff handbook, and your letter of employment that govern your relationship with Intercontinental PLC.
Yes.
Okay. And I now added that apart from your letter of employment, your letter of employment must have been issued to you sometimes in 2000. But as the event unfolded, you were promoted one way or the other at a particular time. So with those promotion comes a letter notifying you of the promotion. Are you on the same page on that? So I'm now that it is all those other letters that will also be governing your relationship with Intercontinental Bank PLC.
You are correct.
Thank you very much. So, as a staff of Intercontinental Bank PLC, you did mention that sometime in 2005, that Intercontinental Bank PLC had some mergers with other banks. You can refresh your memory, you can look at paragraph 9 of your witness statement.
Okay. Go ahead.
Okay. So,
the main file.
So as at this 2005,
yes,
the defendant in this proceedings, that's Access Bank, was not part of that system, was not part of that merger at all.
Access Bank, as it is now, as a defendant.
Come again, Mr. Laidi. I didn't hear that part.
Yes, my lord. The question I was asking him was that in paragraph 9 of his witness statement or note, he did mention that there was a merger in 2005, which comprised 4 banks. That's Equity Bank of Nigeria, Gateway Bank Limited, Global Bank Limited, and the defunct Intercontinental Bank PLC. So the question I now put to him further to that paragraph 9 is that Access Bank from that paragraph 9 was not part of that 2005 merger whatsoever.
And I'm saying that Access Bank, up to the acquisition of SY Intercontinental Bank, was not a part. But why they are defendants in this case today, they are now acquired the assets and liabilities.
That was not the question he asked you.
Please, for us to make
question he asked was that Equity Bank, Nigeria Bank, Global Bank, and Intercontinental Bank were the only banks that were merged.
Yes. Yes.
Am I?
Yes.
What you wanted to ask?
Yes, my lord.
Yeah, that is only bank. Yes.
So I will be right to put it to you that as at that 2005, Access Bank was not part of the arrangements put in place by those banks that merged together.
That's already a statement you've seen, but I will say you are right, and I put a but.
What was the but about?
Because what he's telling me is obvious. A merger that occurred in 2005, Access Bank acquired Intercontinental Bank in 2011 ending. So of course it's not a merger. I mean, it's not of it.
Here's the question.
Please, Mr. Megwa, just try and limit yourself to the questions I have asked. If I have made, you will record that what I said was that I will be right to so make that assumption. Yours is just to confirm that yes, you are right. Please, just let us make progress. There is no cause for us to quarrel with one another or each other. Now, in that 2005, you did mention that because the banks that merged together became the defunct Intercontinental Bank then had different policies on gratuity, right?
Yes.
That the defunct Intercontinental Bank that has its own policy on gratuity more or less put a policy in place as far as gratuity is concerned after the merger of those four banks. Is that correct?
Yes.
Okay. I will be right to also state that the policy that was in place then on gratuity as the time frame for the staff's entitlement to those gratuity. In other words, in that 2005 policy on gratuity, it's not automatic that once you are a staff, even if you are employed yesterday, you become entitled to gratuity. You must have spent a certain number of years before being entitled to gratuity. Is that correct?
I'm not an expert on that side, so I don't know. All of that was trying to advise me my own gratuity. I'm not an expert on it. Human capital people should clarify this to you, whether you're correct or not.
Mr. Megwa.
Sir.
You are the one who brought us to court.
And I've told you I know. So you are not doubting what I know. So what I know is still what I know.
So tell us what you know. So you don't know. Are you telling the court that you don't know that if you are employed in a bank or as you are employed in a Intercontinental Bank, then you don't know that there is a time you spend in the system because before you become entitled to gratuity. You are not aware of that?
I told you you're asking me a policy question. What concerns me is what I was advised as affecting me because I spent 5 years by then in Intercontinental. You're asking me a policy which I don't know because I'm not in that department. But I was advised what my entitlement was after the merger.
Mr. Amegua, we don't need to be confrontational. If you don't know, please listen to me. Please listen to me. If you are asked a question and you don't know.
Mr. Laide, he said he doesn't know.
As accomplices, I take that.
He doesn't know. He doesn't know.
Yes, I'm grateful, my Lord. Now, in that 2005, you, yes, in your claim, put forward an amount you believe you are entitled to. Is that correct?
You said? Cancel. You said what?
In his claims before the court.
Yes. 2005.
Yes, he put the amount he believed he was entitled to in 2005.
And I said yes, cancel.
Okay. Do you have any materials, document or anything before the court to show that that amount you put before the court as your claim is what the defunct Intercontinental Bank PLC advised you on?
I think, I mean, because of reflection of time, I don't have, but that was what I was advised and every other person of my grade. So I don't have, I don't have that now, but also I think we tendered the staff handbook as applicable.
Well, tell us now, where in the staff handbook is already in the exhibit? Can you please tell us where the staff handbook that made you entitled to the amount you are claiming before the court?
I don't have access to the staff handbook.
Follow me. Where are the exhibits?
Thank you very much, my lord. My lord, I want to see this.
Where are the exhibits? The handbook.
So please upload the handbook and let him tell us or advise us.
Yes. Exhibit AOM 5, page 1 to 44. Page 1 to 44. Page what? Refine me. Has it been uploaded?
I believe so, because it's actually a document they tendered as exhibit, so it's already an exhibit before the court.
Well, I have the hard copy here with me.
Yes, my lord.
Exhibit AOM 5, yes, page 1 to 44. So,
And in order to make progress, perhaps if his counsel can assist us, because I believe he will also have a copy of the hard copy with him, so that when they are looking for it, we can just make progress.
Was it not front loaded?
They have it is front loaded, my lord.
Okay, Mr. Lydia, do you have a copy there?
I have a copy, but he's the one who is expected to show us something inside it.
Refer me to the page you want to ask the question, so we can move forward. I have a courtroom full of lawyers here waiting for me.
My lord, the question I asked to him is that where is the evidence showing that the amount he's claiming is what he was advised by the defunct Intercontinental Bank president?
Mr. Mengwa, you have a copy?
No, I don't have a copy of the handbook.
And he told you.
Mr. Mbaka, do you have?
Yes.
Because you front-loaded it, you must have.
Yes, they have the soft copy. The soft copy is the host.
Okay, look at the soft copy and tell us where he's referring to, what he's entitled to.
The soft copy is uploaded to the host device, which is NICN. NICN can share screen and load it, but if that will be challenge, they can make me a co-host. I can upload. I can.
Please tell Folami to do that for us,
so that they can ask questions on what they want.
You have a soft copy. Okay.
If they made me a co-host, I can show those documents. They have soft copy, so they can upload it from their own end if they are also made as a co-host. So it's the work of the registrar.
Talking about you people who are better positioned.
Yes.
As we are talking to, as we are making this, hearing this truth, I have a courtroom full of lawyers and litigants, and they are waiting. And you know, today being the last day of the legal year.
My lord, I appreciate my lord's patience and concern, but we are just about to even start. If the witness is physically present, it's just a matter of giving him a copy and we make progress.
They are trying to see what they can do.
As the court pleases.
Can we go forward with other questions, then we can get back to that one to save time?
I will try.
Oh, it will be imperative to the leading questions, the questions that will be left from there.
It is.
It's all right. We'll wait. Excuse me. Mute me.
I don't know why it's not coming outside. So make him come outside. I don't understand.
This is. if it's possible for the admin to co-host Mr. Carlos Mbaka so that perhaps he is in a position to assist.
Whose device? What you are seeing, the staff handbook is what we have on the screen now. Council, if you are looking at your screen, the staff handbook is on the screen.
What do you mean by if I'm looking at my screen? Where else would I be looking at? So, Mr. Megwa, what we have uploaded on the system now is the staff handbook which you tendered. Can you please refer us to where the claim of, to be specific, 6,046,302 naira 71 kobo was endorsed as your entitlement? Can you hear me, sir?
What you've displayed is, I've seen only a page. I need to read the whole handbook, please.
You talk, I'm not the one showing it.
Am I back?
Scroll it.
Okay, no, forget about the video. Yes, we were logged out separately, but we are back now on the system. I can see the introduction, the corporate profile. So, Mr. Mengwa, can you hear me?
Yes, my lord.
Okay, direct us to where you got your computation from.
Let's go down. I mean, because this story had just ended on October 10, 2005. What's the next page?
Continue.
No, I think you should just scroll it page by page so that they have the time to look through that page before it is taken up.
My lord, if
I saw something from page 30 to 31, maybe we should just go straight to that.
Because
Evidently, the one we have here is not paginated.
Oh, it's not, yeah, I can see it's not paginated.
Number by paragraphs. Paragraphs will be much easier.
From 4.5.
4.6, 4.5. Yeah.
Yes. Yes. I'm down. Yes. Go up. 4.6. Yes.
So 4.3, is that what you have in mind?
I'm sorry, my lord. This, if I may be allowed to speak a little.
Yes.
The question Mr. Lydie is asking is already answered by another document which is already in evidence. The gratuity advice is already in evidence. So if you are asking whether the company handbook states specific figure 1, 2, 3, 5, 6, 7, 8 in amount of entitlement of a gratuity, that one, I don't know whether that is the question, because there is no figure here in this handbook. But if you are saying entitlement to gratuity, the scheme, the gratuity provision is stated here in the handbook. And then there are other policies you also mentioned in your earlier question. So we can see.
Mr. Ambaka, please don't try to be clever or smart. I never mentioned.
Mr. Laide.
Yes, my lord.
Please, I want you to take that back, because that statement is what is going to inflame this situation and will not make any progress.
I'm sorry.
See, it's not easy making, you understand, a virtual hearing.
I understand, my lord. I apologize. But what I wanted to mention is that I never mentioned the policy manual as being the one who contained it. It is his witness who mentioned that the evidence of what he's claiming is in the staff policy manual. That's what informed us uploading it. I never mentioned it. And if he himself knows that there is an exhibit he has tendered which shows that amount, I think it would have been much easier for him to say, other than this, so we can also look at the exhibit so and so, and it will be uploaded. That's my own concern, because this issue of attributing what I did not do to me is very, very unfair. So let us know if it is not, if what is here is just a generic gratuity for all the staff of the Fund Intercontinental, fine. If you have specific one that talks about the amount I've just mentioned now, you are claiming 6.4 million as your major gratuity of 2005. Then the lawyers should please let us know. Look at the so and so, and we make progress.
I'm listening.
So I'm waiting for Mr. Ambaka or his witness.
I'm waiting for all of you.
As the complicit. Because
myself, again, there's no staff handbook in any company that will tell you every staff exact amount. Is only a policy of how it should be calculated. So that's the reference to the staff handbook, is how my entitlement of that amount arose. And I've said it here, by then I've worked for 5 years. So, and it stated there that at the merger, they operated different types of schemes with Intercontinental Bank.
Mr. Amegba, we don't need to waste much time on this. What I'm asking you is, do you have any evidence before this honorable court showing the exact amount you claim has been the amount that the Intercontinental Bank PLC advised you before you start claiming it? So that's what led us to this manual. I don't even know the content. You are the one to advise me or to educate me. And I'm saying, even if it is not here, as we've seen that it is not here now, you should let us know if there are any other exhibits. Your lawyer was trying to make reference to a particular document. If you can avail us of the exhibit number so that it can be uploaded and we make progress.
I said on my own behalf, after the merger, every staff was advised of
please.
And so I was advised, I've left Intercontinental Bank Nigeria since 2006. And that's one of the things that if people like Dr. Tijani, who were then manning that desk, were here.
Please, in order to make progress, just confirm to the court that presently, before the court, there is no document showing that you are actually advised of this particular amount you are claiming before the court, and we make progress. If there is, you show us.
I won't take what you're telling me. The court, I was advised, but I don't have it here. I was advised. It didn't come from my head.
Can you produce it? Can you produce it?
I can't produce it now.
Okay. Yeah, maybe you will produce it later. But did you read through the statement of defense that defendant filed in response to your case?
I did. Yes, I did.
And you are aware that the defendant denied your entitlement to that claim.
Yes, I'm aware.
Okay.
Come again.
He said he is aware that the defendant denies his entitlement to that pre-merger of 6-point-something million in their statement of defense. He said he's aware.
And the defendant denied
that he is entitled to that 6.4 million and indeed require strict proof of same before the court. He said he's aware. Now, admin, I think you can drop the, but before you drop that one, because there's actually another question I want to ask on the policy manual. Mr. Megwa.
Yes, counsel.
Are you aware that by virtue of clause 2.11 of that policy manual, please, can you please scroll it to clause 211, 2.11?
It's on the screen. You can see it on the screen. It's in bold. Look at the screen. Clause 2.11.
Now, based on this clause 211, if the staff in question is
211 or 212.
Do we have 212?
Because the one that is in evidence, 11 is vehicle maintenance bonus for drivers.
And
212, refund of upfront payment advances.
Yes, my lord. That's the same handbook he's making reference to. The one on the screen, shared on screen now.
My question is, based on this clause 211, where a staff has collected any upfront payments or advances, either through leave allowance or any other allowance in the system, as at the time of exiting the bank, such a staff is expected to refund whatever is owing the bank. Is that correct?
Yes, you're correct.
Okay, thank you.
Gentlemen, this 211 you are reading in evidence that I have marked is reading 212.
My lord, the one we have here is 2.11. I don't know.
The one I have here is 2.12.
That means they have actually.
But the topic is correct.
But the danger is that what was uploaded, which is what we have here, what was uploaded is actually what they front-loaded. The implication is that what they tendered is different from what they uploaded.
Maybe typographical errors.
There are two. The same uniform handbook. The defender also front-loaded. We uploaded theirs. They say we should convert it to digital format. So the two handbooks front-loaded by defender and claimant are what we have before the court. So you are the one you are making reference to. You can particularize. So my law can note it. These handbooks are before the court. You front-loaded a handbook. Claimant also front-loaded a handbook. So if at the end of the day the handbooks are different, you will clarify. So you have, if paragraph 2.11 is what you have in your mind, that is what the claimant is relying on.
Mr. Mbaka, please. I'm not the one who made this observation. It is his lordship. Why are you so it is his lordship who said that the one his lordship has 211, 212. And I said the one we have here is
gentlemen, what I'm saying. In your own that you are talking about too is vehicle maintenance bonus for drivers.
The one that
212 is a refund of upfront payment advances. Words are correct, the same word for word.
As the court pleases, my lord.
No, you understand? So it's just the numbering that is the problem.
My lord, it's more than that, my lord. Because that means we are talking about different sets of staff handbook. And the one we have and the one that was front-loaded, if it is different from the one they tendered, then there is a problem because we don't even know what are the other clauses in the other ones. Meaning that the 211 we have is not, because as my lord will observe, there is 211 there and there are 211 there as a different subheading. If we want to address my lord now in our written address, definitely we will be making reference to a different thing or a wrong thing. That's why we need to know. There shouldn't be an ambush anywhere.
No, it's not an ambush. That is the reason why I did it.
I appreciate my lord's position.
I can understand that maybe it's possible error in the numbering.
No, if it is error, it couldn't have been an error by any of the party. It must have been from Intercontinental, and we should have copies of all those ones. Because as it is now, we don't even know the nature of the one that my lord has. We don't know how many subsections it has before chapter 3. I don't know whether Mr. Mbaka will see any wisdom in my position, but that's our predicament. The ones that we front-loaded in our statement of defense also has 22.11, and 2.11 that we have here is the same with the one that has just been uploaded now, which is titled refund of upfront payment. There is no, even the one he front-loaded also has 211. So how come he tendered a different one? That's the issue. Because the copy that Milo has now, we don't have it. It's beyond just a typo.
And that's important. Let me just please come back again from 2. Let's start looking at out of station work. Out of station work is correct. And 2.2, 2.1, and then procedure for raising out of station and 2. Allowance. Then 2. Let me see 2.4. Okay, you see, even here they don't have. Okay, yes, 2.4 entertainment allowance, which is what is not here. It's entertainment allowance that is not here. And then dressing allowance, transportation. Take it up. Staff Department of the Month Award. Yes. Profit sharing scheme. Go up, go up. An official duties. Vehicle maintenance. That is missing in this one. That is the only thing.
Well, my lord, to the extent that
I declare it's a typographical error.
Well,
maybe you people should address me on it.
Because our position, my lord, is this.
Yes.
The one with typographical error,
yes,
was not at any point in time brought to the attention of the defendant as well. It was not front-loaded. Then the one that we also front-loaded at the staff handbook also does not have that error.
Reserve it for address now.
Is in the course of our final written address, we will be making reference to these paragraphs to buttress our submissions. We don't even know, we have just checked between 2.0 and 2.11 and we noted this. We saw that a particular paragraph was omitted.
Omitted.
And the one that containing this deletion, we don't have it. Maybe not, I don't want to say.
What will happen is let this one take precedence, the one that we have. It's called cool. Entertainment, it is there. Is it there? Yes, but that still doesn't. But it's here, and this one is here. What will happen is we have to use the one the court has.
And
So
I
have to have a date. I don't know. You decide what you want to do amongst yourselves.
My lord, in fact, while we may not be asked to have a date, my lord, given the stress we are going through, the next proceeding will have to be, God willing, physical, my lord, because we are displaying so much energy, and we pray that by the time the court resumes from vacation, Corona will have been defeated by God's grace, because this is really not palatable at all.
Who is Ronald? What are you talking about that will be defeated?
By God's grace, my lord.
Oh, Corona. You're talking about Tell me, Mr. Lady.
Yes, my lord. So, from all the indications, my lord.
Oh, Corona. You said Corona.
COVID-19, my lord.
Oh, I said
COVID-19 will have
it's all right.
Yes.
It's all right. It's all right.
We need to have a look and a study of the copy that my lord has accessibility. This is not what we have.
All right. Mr. Carlos, what do you...
My lord, we will make photocopy of what is in the cost file and upload to them if that is his
upload. I think that will be better.
But if he has any other question he wants to ask, he is free, because the documents have no, the two documents are from the same defendant. We do not author any copy. It's the same thing we are giving. We did not author any document. It's the same thing that was.
Mr. Lady?
Yes. If we do not author a document, but they have done certain things to the document, we need to see what is before the court. But I will continue. Definitely, we need to continue, and that continuation will definitely have to be physical. Now, I don't know whether my lawyer has given me the permission to proceed.
Yes, go ahead.
Yes, my lord. Now,
you know your cross-examination is sound, even though it has been in times.
My lord, I didn't get that.
I said your cross-examination has been several times, but you are time-bound.
Time-bound?
Yes.
My lord.
You know about our rules that put time for cross-examination.
My lord, I'm not aware, because what I know, with due respect, my lord, is that defendants should not be I'm twisted as far as the defense is concerned. Is a constitutional provision. If Melo is
nobody is there in the rules. Look at our rules.
If my Lord agrees with us that we are indeed making relevant points in the cross-examination, but we have just touched on one.
I'm only telling you what the rule says. Of course, within limits. You understand? I should give you how much more time I should give you. We should.
My Lord.
I'm not saying, I'm reminding you that you are time bound, even though it has been interrupted.
For no fault of ours, my Lord.
Well, it's my fault. You know, it's my court.
No, my Lord, it's not my fault. It's not fault. It's because of problem of uploading or not uploading.
Yes, it's all right.
But I will very passionately plead, my Lord, that nonetheless, the court should give us sufficient time to do justice to this, because the whole essence of this
to it
is for the court to actually ascertain what
the claimant, the defendant, both sides, they deserve to be well ventilated.
As the court pleases, my Lord, I appreciate that, my Lord. In fact, for almost 20 minutes now, we have been talking about the court.
It's not up to 20 minutes.
As the court pleases. The issue that the document that is before the court and the one front-loaded. So, my Lord, before the adjournment, I want to take some few more questions.
Okay.
Yes, my Lord. Now, Mr. Amegwa, can you hear me?
I'm hearing you.
Okay. You resigned your employment in the defunct Intercontinental Bank in September 2011. Is that correct?
You what?
He resigned. He tendered his letter of resignation with the defunct Intercontinental Bank in September 2011. Is that correct?
That was a constructive resignation, yes.
Did you write a letter to resign your appointment in Intercontinental Bank in September 2011?
And I told you it's constructive resignation. I was advised to do that.
What I want, yes or no?
Sorry, I also have right to answer you the correct, because you want to box me into a corner, and I'm telling you what happened. So it's just your
I'm not boxer, Mr. Megwa. Now, in that your letter of resignation, you did give to the defunct Intercontinental Bank PLC 3 full months as notice for the resignation to take place. Is that correct?
In the letter you referred to, yes. And I still said under constructive resignation, yes.
And you actually spent the entirety of that 3 months with the defunct Intercontinental Bank PLC. Is that correct?
Yes.
Okay. Now, being in the system in 2011, before Access Bank, as we have it now, eventually took over or merged with the defunct Intercontinental in 2012. Are you aware of circumstances leading to the takeover of Access Bank, at least for the last 6 months in 2011, from the middle of 2011 till the end of 2011? Are you aware of the step that Central Bank of Nigeria took as far as Intercontinental Bank is concerned?
I don't know the detailed steps, but I was aware that from 2009, Central Bank dissolved the board and management of Intercontinental Bank and set up their own appointed board that oversaw Intercontinental Bank till I left.
Okay, till you left in December 2011.
You said you did not know what CBN.
He said he knew that in 2009, CBN dissolved the board of directors of the defunct Intercontinental Bank, and that. My lord?
CBN in 2009 dissolved
the board of directors, the management of defunct Intercontinental Bank PLC. And it was that new board set up by the Central Bank of Nigeria that were in place in Intercontinental Bank as at the time he left the bank in December 2011.
So I wasn't aware of the steps of CBN.
Okay, but you are aware that the directors and management in place were the ones that were appointed by the CBN as at the time of your departure.
Yes. Yes.
And are you also aware that Access Bank took over the management of defunct Intercontinental through a merger in 2012?
I'm not aware of that because even when I was still here in Ghana, the current group CEO of Access Bank and his predecessor even visited me in the office here in Ghana for meeting. So they were already taking some steps that, they're already part of it.
Yeah, that's what they call due diligence. But can you look at paragraph 4?
Is witness statement or not?
Paragraph 4 of your witness statement or note.
Some of them taking dates. Only one. All the way.
This procedure is very slow. Have you seen it? Paragraph 4.
What are you referring to, paragraph? So I know that it is what I have. Please.
That's where you said that my relationship with the defendant.
Yes, yes, it is.
You've seen it.
Yes.
Based on that paragraph 4, Access Bank consolidated or merged with defunct Intercontinental Bank in 2012, as known today. Is that correct?
Yes, based on this.
Okay.
That must be the legal date, yes.
So, at no point in time were you under the employment of Access Bank before you left Intercontinental Bank PLC in December 2011?
Are you asking me a question or?
Yes, I'm asking you that there's no evidence before this court that as at 2011 when you left defendants, that's the Intercontinental Bank, Access Bank was actually your employer.
But I've never claimed that.
Okay, thank you. Now, look at exhibit AOM 4A. That is the letter that was dated May 30, 2012.
Sorry,
what?
You said
Exhibit what?
AOM 4A, my lord.
AOM what?
4A.
Exhibit AOM 4.
That's the letter dated May 30, 2012.
I'm sharing screen, so please take a look at the screen so you can see the document.
You have seen that letter, Abi?
Look at the screen.
okay. Yeah.
Okay. That was a letter that was written to you in March 30, 2012 by defendants. Is that correct?
No, May 30.
Yeah, that's what I'm saying. May 30, 2012.
Yes.
In that letter, your gratuity was put at 21.6 million.
That's what is the letter, yes.
Then your end December 2011 salary was also quoted as 417. Then we have the total being 22.018. That gratuity of 21.6 accords with what you are claiming as your entitled gratuity. Look at paragraph 20, to be sure of what I'm saying. Look at paragraph 21 of your witness statement.
Yes.
And starting with paragraph 16. Look at paragraph 16. Are you using paragraph 16 of your witness statement?
Paragraph 16.
Yes.
So in that paragraph 16, you did mention that indeed the entirety of your gratuity as at that date was 21.6 million, which is the exact amount that is in that letter of May 30, 2012.
Please. Yeah. Yes, and it's clear that it's a post-merger, November from 1st November 5.
Yes, we are saying the same thing. What I want you to confirm is that the claimant, the defendant was actually right when they inserted in that particular letter of May 30, 2012 that your gratuity is 21.6 million.
But they didn't check my interest into consideration. Look at that same paragraph 16. Read the whole paragraph, please.
Just listen to me. Just listen to me. First of all, let's start from the known to the unknown. You know there is a base figure. What I'm saying is the defendant calculated your gratuity as at the time of your departure or exiting the bank in 2011, and they mentioned that you are actually entitled to 21.6. million. And that is the same thing you put here in paragraph 16.
And I told you, yes, but that is post-merger.
Yes, I know, it's post-merger.
Yes.
Now, the one in regard to how you arrive at 26 million, you said it was an interest.
That's correct.
Okay, and that was as at the end of April 2013.
Yes, as I when I started comparing, making up this case, yes.
But the one that was communicated to you was as at December 12, 2011. That was the effective date that you resigned and exited the defunct Intercontinental Bank PLC. Is that correct?
That was the principal sum, please. The interest accrued therein was not included in that calculation. That's the argument.
Mr. Megwa.
Mr. Lawyer.
No, Mr. Masa, don't answer his question. Don't talk to him. Leave him. If it's my Lord you respond to, you are answering to my Lord, not to him. If you are provoked or you are made to feel angry, just leave it to me to apply to my Lord, to talk to counsel, to tone down his voice. He wouldn't be aggressive to you. Respond only to my Lord. If he says something that makes you angry, I am in this trial. I will talk to my Lord to address counsel so that we'll make it friendly and then move on. Thank you.
Okay.
Mr. Megwa, can you please read the first paragraph of that May 30, 2012 letter?
It's on the screen. Look at the screen. Yeah.
Yes, I've seen the paragraph.
Yes, the bank sequel to your resignation of your appointment with the bank, effective December 12, 2011.
Yes.
Please be advised of your account position as follows, or as shown below. So the point I'm putting to you is the 21.6 million was calculated upon your exit from the bank on December 12, 2011, because that was the day you last worked. So if they want to calculate your entitlement, your gratuity, it's not going to be at a later date when you are no longer in staff. It has to be the last date you spent. Is that correct?
Yes.
Thank you. Now, in that same letter of May 30, they also listed your indebtedness. And as you will see on the screen, we have on any fourth quarter upfront allowance, 2004 public offer, 2006 public offer loan, 2009 special share, on-hand 13-month allowance, on-hand passage and leave allowance. All of this, your indebtedness, summed up to 28.334 million, based on what is there. Then it also listed indebtedness to Ghana subsidiary, which amounted to 1.4 million naira. Now, will you agree with me that since you have 22 million as the entirety of your gratuity as at 2011, and you are also owing 28.3 million as at that particular date, at least for the one in Lagos, the defendant is entitled to ask for refund by netting off your allowances from your indebtedness. And that's what the defendant did. Do you agree with me with that?
Based on what we are seeing on this letter, yes, you are right.
Okay, thank you.
But the whole essence of this sitting because calculations were not right, were not rightly done.
Okay.
Yes.
Do you have any other calculation that shows how it could have been calculated?
You could see if
before the
court. My statement of claim number 14, paragraph 14, is not in this calculation. That's one big one that is not there.
Okay.
But
wait. The letter itself confirmed that it was actually the one as at December 12th, not the pre-merger, because like you did testify before now, Access Bank, who took over from Intercontinental, were not in the system as at 2005.
Just like they were not in the system as at December 12, 2011. So why are they talking to me? They were not in the system also, because they came in.
Yes, they were not in the system.
So they shouldn't be talking to me at all in December 12, 2011.
Okay. Now, of all this indebtedness that we have in that letter of May 30, 2012, are there any that were not actually given to you? As in all those on the fourth quarter 2004 public offer, that is what is actually the correct position as far as your indebtedness are concerned, as at May 30, 2012.
From where you are sitting, that's why I said I'm from and say it is not correct. Even if you go by the loans you listed there, go to your own counterclaim and see that it's different.
Please listen to me. You are the one who tendered this letter. And I'm saying there's nowhere in your claim to say they listed A or B or C of these loans, and it was actually not given to me. It wasn't your case before this court. Now, having said that, you got this letter in 2012. Is that correct?
Yes, counsel.
The defendant filed a suit against you in Ghana in 2014 to demand for the mortgage loan given to you. Is that correct?
Yes, counsel.
I'm sorry, my lord. That question is not correct. The defendant here.
I'm sorry, my lord.
I'm sorry, my lord. The question has to be rephrased. The question is not the defendant. The defendant in this suit did not file any suit in Ghana. The defendant here is Access Bank. Access Bank PLC. I have to correct. You don't mislead the witness. Access Bank Ghana Limited or PLC is different from Access Bank Nigeria. So guide the witness properly. The defendant here, Access Bank PLC, did not file any suit in Ghana. So if the witness can be assisted properly so that the court will record also correctly and properly. Help the court to do justice, please. Thank you, my lord.
My lord, I think I will seek my lord's and protection. Because I had the witness answered me. He interjected and started giving.
You answered me. You asked me a wrong question, Mr. Counsel.
Let me come in. Let me come.
Please take time to answer. My lord, sorry, I'm sorry.
Madam,
who actually in Ghana?
Thank you, my lord.
Access Bank Ghana.
My lord, I didn't hear what you said, man.
I said who?
The case was between Access Bank Ghana Limited and Albert Megwa.
Okay.
My lord, in your
stopped.
It's on the screen for guidance, please, my lord. I've uploaded the document, the suit they are referring to, my lord. the Ghana suit is on the screen now, my lord.
Now, please hold on. All those processes in Ghana, the writ of summons, the statement of claim, and your statement of defense. My lord, I seek to tender them in evidence, my lord. In fact, the defendant, the claimant pleaded them and said he will even rely on his statement of defense, but inexplicably, it wasn't tendered. So I don't think it is an issue. So I don't think it's an issue that you require any unnecessary arguments. So we seek to tender the processes that were filed in Ghana. We pleaded them.
Are you tendering them through this witness, or are you going to do it when you have your own witness?
I'm tendering you through this witness, my lord.
Because it will be quite cumbersome doing that on virtually.
No, my lord, we will let the witness identify it, then we can move on. My lord, it will be easy. My lord can note it on paper, then the physical copy will be brought to the court. So long as they confirm what is on record, what we have to unload. So look at the first page, if it is okay.
Is that okay? Are you comfortable with that?
Yes, my lord.
Okay, go ahead.
So let me scroll down. So you look at the pages and then confirm if they are the Ghana suit. This is the first page. I'm scrolling. Look at the pages. That's the writ of summons. This is the statement of claim by Access Bank Ghana Limited.
Just a second.
Okay, my lord.
No, I'm not a typewriter.
Writ of summons. Dated 25th April 2014. Statement of claim as well as a writ. This is the statement of claim of Access Bank Ghana. So we are going scrolling now to the defense to that suit. Confirm if this is the suit number, and if it is the suit, this is the statement of defense. Look at it. If it's your suit as defendant, look at if it's your statement of defense in that suit. You are scrolling up.
Dated what?
I'm scrolling to the date page, my lord. Look at it, witness, if it is your statement of defense in the suit, paragraph.
I'm not reached the statement of defense. You are pushing me too hard. I'm writing.
Okay, sorry, my lord. Let me go back to the statement of claim. Statement of claim of the claimant.
Statement of claim and the writ are dated what?
Are dated 25th day of April 2014, my lord.
Okay.
Mr. Lydie, confirm is your document. Please look at your document.
Is that the document you are talking about, Mr. Lydie?
Yes, my lord.
Okay. Mr. Mwenga, are they the ones? Are you identifying them? You can see them on the screen.
Yes, my lord.
Okay.
But the only observation I have is that, or maybe
yes,
I should ask them to
come in. Yes. Hold on. Yes.
Maybe I should allow them to conclude this quickly, because there is a document that is supposed to be together with the statement.
Just leave it. No problem. I understand very well. Yes. Yes. But please, excuse me. Sia, please explain to them. Let them hear it from your own mouth.
We are sorry. was a major fault or something that one since Monday. But that's really not an issue. But the thing is, the level we have, if the generator goes off without us power, we may not be able to, because
it will crash.
So we are sorry for the fact that we may not be able to provide.
I don't want them to believe that maybe I'm trying to run away because I can't go through a hearing without power. And even the partial hearing we are going, the battery is going low. I just don't understand. Yes. Wallahi, I'm so sorry. Maybe you will have to do it online. All right. Okay. We'll do that one. Yes. Yes, Mr. Omega, you have identified that one?
Yes, my lord.
Oh, okay. Then continue.
Statement of defense, page 1, page 2, page 3, page 4, page 5, page 6, page 7, counterclaim, page 7, page 8, page 9, dated 30th day of June 2014, my lord.
Huh? What's this? Yes.
Yeah, there's some others.
Yeah, that one that we have been writing.
All right.
Yes.
Do you confirm the statement of defense and counterclaim witness? Witness, the statement of defense showed, did you confirm it?
Yes, I confirmed it.
I will attend to you.
This is a statement on oath on behalf of the plaintiff. Is this also confirmed? Dated? There's no date on it. It's February 2016, but no particular day of February. Do you confirm this also?
What is that document?
Witness statement on oath of plaintiff witness.
Okay, of plaintiff witness.
Yeah, filed February 2014, my lord. This is plaintiff witness, Miss Anne Obeng Abadio. You confirm this witness?
Yes.
Dated February
2014.
February 2016 or 2014?
2014, my lord.
Okay.
This is a exhibit front loaded in the same suit. It's a letter in the suit dated 24th May 2016. Defendant, which one are you tendering? Are we also adding this, or is it the process you want to tender?
No, we add this.
We are tendering, and there's also the
okay, Okay, terms of settlement. Your witness confirm this also?
Yes. Yes.
Okay. Terms of settlement?
Yes.
Okay. Terms of settlement is dated 4th of May, my lord.
Just a second.
4th of May, 2016, my lord.
Terms of settlement.
Yes, my lord.
Dated?
4th of May, 2016. Yes, it's on the screen there.
2016, okay.
Yes. Following this terms of settlement, my lord, is another document, entry of judgment, the judgment of the Ghana court, my lord.
Okay.
Is dated 16th of May, 2016, my lord.
16th?
16th, yes, my lord. 1/6
of May.
Yes, my lord.
2016, okay.
Yes, my lord. That is the end of the Ghana processes, my lord.
Yes. I'm listening.
We only apply to tender those set of documents in evidence accessible.
Okay.
My lord, we have no objection to the tendering of the documents. We urge my lord to admit them. We are also relying on the documents, my lord.
They admitted in evidence. We'll give them the markings when we see them physically.
As the court pleases, my lord.
Yes, my lord. Now, as at the time that this suit commenced in Ghana in 2014, you had already been advised of your terminal entitlements or benefits by the defendant based on that letter of May 30, 2012. Is that correct?
Yes, counsel.
Come again, Mr. Lady.
I put it to him that as at the time the suit in Ghana commenced,
yes,
he had already been advised by Intercontinental or the defendant of his entitlements, of his terminal benefits.
And I said yes by that letter.
Now, in paragraph 3 of the statement of defense in that Ghana suit, please, can you scroll to that?
Okay.
Paragraph 3.
Okay. With the statement of statement of defense or statement of claim?
Statement of defense.
Okay, sir.
How far? How long do you have, Mr. Laide? I give you 10 more minutes only, and no more.
And no more?
Yes.
My lord, I'm sorry, my lord.
Here we don't have light. Our battery is going to run down. I tell you, I want to continue this some other time.
Exactly, my lord. Because I appreciate the various constraints the court is having, but I will personally plead that we be given some other time apart from today because of the exigencies we are unable to conclude.
We are not really, and I have right now I'm seated in the courtroom with a courtroom full of lawyers.
My lord, I appreciate. We can take the 10 minutes, but I'm just pleading with the court that
no. If you are going to have another time, I wouldn't give you the 10 minutes again.
As the court pleases. Maybe the court can adjourn now, but definitely I will need more than 10 minutes.
We better adjourn that. And then I'll also look at the rules and see if you can have more than 10 minutes, even the next time. I know our rule states that it is time bound.
My lord.
You read our rules now. I didn't make them.
I understand, but my lord is not a slave to those rules. Those rules are to guide my lord. My lord is the master.
I agree with you, but right now, one, it is hot. Two, there had been lawyers that were here since morning.
I understand. That's why
we put the time 1 o'clock, thinking that the court will be finished before then, but we are still here. Only God knows when we are going to leave. And now they don't have lights. We're having issues with our generator. The DCR came in and even explained to everybody. You understand?
I consider we can adjourn now to allow others have a fight.
Yes.
But only pleading that we should be allowed to ventilate our case properly.
We'll handle that when we get there.
As the court pleases.
So when are we taking it again to continue the whatever?
And the physical one.
Examination. And Mr. Mwenga, when are you going to be in Nigeria? Since you are in Nigeria.
Yes, tell us to know where to adjourn.
My lord, the issue that since this case started about 4 years ago, I've always been in Nigeria. But due to circumstances, either the court or the defendants, even the last time I've started this crossing.
You know, your matter has an issue because I think it was one of the cases that was because of the transfer of some judges.
Yes.
So you see, that was one of the reasons why it took longer than that. But National Industrial Court, they are always up and doing and wanting to see the cases getting done early. We don't keep cases here, really, on a very serious note. So I will say I'm sorry about it taking that time, but it was something maybe beyond the control of the court.
As the court pleases.
Okay, my lord.
So I assure you, if you give us the time you're going to be here, I think it will be a very good thing. So I will wrap this thing up once and for all.
As the court pleases.
My lord, I will prefer you give a date. I'll make myself available. Try and make myself available.
Okay. Give me a date in October, within those days that I told you of our life.
That'll be perfect, man.
October 21.
That'll be perfect, man.
By the grace of God, so long as we are alive, even if we have some other assignments, I'll make sure that the court is on ground.
Yes, ma'am.
Yes. All right. Is that okay? October 21 for everyone? Carlos.
Yes, my lord. 21 is
possible. Are you live?
Okay, my lord.
All right.
My lord, can we be given a particular time of day, or is it morning hour?
Oh, it's morning hours.
The witness is coming from outside jurisdiction. We don't know if he's going to arrive in Nigeria that day or he will arrive in Nigeria before that day.
He should arrive a day before so that he can run and close this matter once and for all.
As the court pleases.
And the defendant just finished.
As the court pleases, we are very grateful, my lord. My lord, I wish to make a prayer, my lord, that the defendant has to help the Supreme witness to come to court on the next day, my lord.
You said what?
I want to pray, my lord, to help me beg the defendant to assist in helping their witness to attend court on that day to bring the.
They will.
Thank you, my lord.
I believe they will.
My lord. But the position, my lord has already ruled that the claimant has no basis for subpoenaing our own witness. And it was on that basis that we were given a copy of the notice to produce, and we have produced those documents. If they want to it should be another witness, not our own.
I'm sorry, my lord. I never gave them any notice to produce. I have never issued any notice to produce.
The subpoena you gave us.
Gentlemen, don't start that now. On that thing, let's sort it out. Let's see eyeball to eyeball. Let's handle that.
Thank you, my lord. I didn't serve you. I didn't serve you any subpoena. I put you on notice that your witness, your client servant, which is the branch manager, is on subpoena. So you can also help to tell the defendant to persuade him to come and tender the document and answer questions on it. The document that they authored.
If that one is in US, don't worry about that. We will take him live online, and then we'll finish that one.
Thank you, my lord. I'm very grateful, my lord.
Yes.
Thank you, sir. My lord, may I beg that the witness be asked to step down from the oath for today?
No, he's allowed. He's allowed. He will even stand down. Even yes.
Thank you, man.
Thank you, my lord.
May God spare our lives so that.
All right, sir. I'm grateful, sir.
Matter is temporarily adjourned. All witnesses are ordered to be present for a conclusive trial on the 21st day of October 2021.
As the court pleases. Thank you, my lord.
On that note, I want to wish my lord a wonderful and restful.
Thank you very much. Thank you.
Thank you, my lord. And wish my office as well as myself wish my lord
all right.
A restful vacation ahead and
thank you
for the rest of the day, my lord, and week.
Thank you. Thank you.
Thank you, my lord.
Yeah.
It's a member. May log out. Thank you.
Logos up. Can you imagine? You come to live now.